Mr. Stanley here. 25 CR 745 People versus Michael Stanley. We are here on a possible disposition. Mr. Stanley, we have several motions pending. I know several of them are yours, and I'm going to be issuing all of those here shortly.
Okay.
Mr. Hillier also had a motion. Have you seen the people's motion as to the request for evaluation?
No, sir.
All right, that was not filed under seal, I believe?
Not under seal, Your Honor.
No, and so it's available to him. So basically what the people are asking me, and I wanted to hear from you on this, that's one of the reasons I want to talk, is they're asking me to order an evaluation for your competency based on your filings.
I think that's pretty ridiculous. I think once you see the other motions and the language in them, they're pretty straight to the point. And what's contained on the record backing that up, the fine lining should come through to all parties. It's a pretty common tactic by them to try to do that when they know they're backed in the corner and don't have much of a case, such as this case. So it wouldn't be the first time I heard that, but I would say that I'm probably pretty competent according to the language in the motions.
Mr. Hillier, I don't know if you have any further record to make in this matter. You know, obviously, I think that I recognize the content of the motions to be of a particular outlook. But I guess I wanted to find out if there was any record you're requesting.
No additional record. The people would still request a competency evaluation. I've reviewed Mr. Stanley's motions, and while there is legal language in there with some sort of goal in mind, we do rest on the language of our motion, which we don't mean to be sounding insulting, but quite.
Objection. We already know about their trying to keep me in proximity of the victim and their genius of that whole nature. I mean, this whole it's pretty obvious what they're
No,
trying
I
to do.
understand. I heard from you, and we'll hear from him as well.
Garbage.
You can finish your comment there.
Thank you, Your Honor. We do believe a competency motion is or a competency evaluation is appropriate at this time. We don't believe that the motions, for the most part, don't make any particular legal sense, and we therefore believe that given the volume of motions the defendant has filed, the nature of those motions, we do believe a competency evaluation is appropriate at this time.
I'm not going to order a competency evaluation at this time. Once again, I recognize the content for what it is. I understand the word we use is sovereign citizen language in there. What I'm telling you right now is, because I want to address real briefly, we got a letter that I published to the people. I don't know if the people saw that. It was from a family member.
It was a recently, Judge?
I can't remember. It was a week or two ago. My point is I want to make this clear because there's these references to the county court, and I want to make it clear that the county court is not like my underling. They have their own court. This is my court. I did grant your request for a change to bond alterations, but as I stated at the time, I cannot control how other courts do that.
Okay.
So I don't get to order another judge, even if it's a county court level. They handle misdemeanors, we handle felonies. That's the delineation, not some sort of a overruling hierarchy unless there's an appeal to me.
Okay.
So I just want to make that clear that I have no ability to grant that relief. I can't order Judge Lynch or Judge Villasenor or any other judge to do something like that. I just want to make that clear.
I appreciate
So that because it's important for that to make that clear because we will have to address that. At this time, I'm not going to order a competency evaluation just based on my recognition of I won't call it a philosophical bend of this with the UCC ones and all this and the without, I understand what that is, okay? It's obviously a discredited and refuted legal doctrine. However, I don't know that rises to the level of incompetent to, I don't think I have enough yet at this point to order that. As we proceed, though, I'm going to set this matter in for for a next hearing. Is there any, because you're representing yourself.
Yes, sir.
We've gone over the advisement about that.
Yes, sir.
And you still intend to represent yourself?
Yeah, I'm willing to take this to a jury trial. And
Okay, that's fine.
That's fine. And I don't really feel like I need any kind of representation for
And certainly that's your right as well, is to represent yourself. What I'm asking is, do you have contact information with the DAs so that this matter can be addressed for our next hearing?
Yeah, I don't see why not. I mean, they have all my address and everything else. I mean, I've been corresponding and serving them with the notice of the motions, obviously, which they got. My question to you is, am I going to be arrested today?
There is a warrant out of another division that is not mine, that there is a warrant that is active. And
So are
so
these guys going to arrest me right here?
they're, at the end of this proceeding, they will.
Okay.
But again, that is not my warrant. That is from another division. So you will be, but let's set our next court date. And we're setting, now, if you said you intend to take this to trial, do you want me to set this for an arraignment? Which means you would be making your not guilty plea at that time and we would set it for trial.
Sure.
We will set this next matter for an arraignment.
So I came out here out of respect for your court. My question to you is, should I have showed up on WebEx again?
Once
I mean,
again,
would you have allowed me to appear on WebEx?
I do not allow anybody to appear on WebEx if they have an active warrant.
Okay. How am I able to get that quash if he's going to,
From that judge.
okay. But he's actively like fighting me, and every kind of ruling you make has been the back and forth.
My rulings and his rulings have to do with our own cases.
Okay.
So my rulings matter in my case, and your bond conditions were amended in my case, but I cannot make him do that for his.
Okay, and did you say that, is there a way to transfer it to this court, or does it have to stay at that lower level?
It is in his courtroom until it's not. That's what I can tell you. And it is in his courtroom. So
Okay.
that is his case. I don't take misdemeanor cases. We're here for felony cases.
Yeah, I understand that.
All right, so we have the 5th of March at 9:30 as our next hearing, and it'll be an arraignment so that you can enter your not guilty plea and we can set the matter for trial.
Okay.
If that's what you're asking to do.
Yeah.
Okay, so we're going to set for the 5th. Actually, we're going to make it 10:30. Hopefully that makes it easier for you. And for arraignment, if you're going to enter a plea, and whether that's a guilty or not guilty plea, we do ask that you be here in person so that you can enter the plea and we can set for trial.
Okay.
All right, because we have to make certain advisements to you about understanding the charges, the possible penalties to those charges, et cetera, and moving forward to a jury trial.
Okay.
All right, so we have our date set. Is there anything else to address? And I will be issuing orders. We've gotten a lot of them, and I've had trials, so I have them ready. We will be issuing orders on the motions that are currently ripe. I think some are not ripe yet, and that we have to hear responses.
Okay.
All right, anything else to address, Mr. Hillier?
No, Your Honor.
And what's the next dates? I'm sorry?
The 5th of March at 10:30, and that is for your arraignment, for you to enter your plea and set this matter for trial,
Okay.
as you requested. That is your request, correct?
Yes.
Okay, just need to make sure that's clear. You can exchange any information you need to with the prosecution so that you can talk with them.
Okay.
If you intend to discuss any matters with them prior to that, because you represent yourself, they can talk directly to you. But I have to give you the warning, of course, as always, as I tell everybody, if anything you do say to them, make sure you don't incriminate yourself.
Okay. Sounds good.
All right, thank you. I'll ask you to have a seat over here. Right. Our last 10:30 is Mr. Stanley, who appears on WebEx 25 CR 745, People versus Michael Stanley. Now, Mr. Stanley, I saw your motion. However, I wanted to address it with you here because I don't know if you intend to arraign today or not. So let me get you unmuted. What I remember telling you when you were last here is that for a plea, not guilty or otherwise, we need to have you in person to make that plea unless the people are willing to waive any objection. Do you intend to plead not guilty and set for trial today, or did you intend, because we can set this for a time when you can get here so that I can accommodate the hardships
Yeah,
of travel?
I'm so sorry. I just can't seem to catch a break. I can't make this stuff up. But whatever, if the state's willing to go with it, I want to expedite things. I don't mean to hold things up. I feel real bad. So if they're willing, I will enter a not guilty if we could do so today, please.
Do the people object to?
People would prefer to have them in person, a standard procedure.
And there's reasons for that. We do it in person. You know, this is a trial setting. It's a plea receipt. We accommodate in many ways. Is there a time and date that I could set that would be convenient for you to get here so that I can help accommodate your travels?
Yeah, I'm sorry, going back and forth and having new bonds written on my name, makes things quite difficult. If the DA could take that into consideration. With that, I'm probably gonna be looking to move out of Pinedale. Not that I'm coming down to Fort Collins, because I don't really like the scenario down there, but maybe somewhere closer in Wyoming. So I don't know what the calendar, how it reflects, if it's 2 weeks or a month. I know it could go anywhere from 14 to 28 days. So, uh,
I mean, if you're
what is
amenable
your?
to the 26th, we have some dates open. That's about 2 weeks out. Is that enough time to get you some arrangements to get here for the plea entry?
Um,
That's 3 weeks.
to maybe push that. Yeah, is there any way to push that maybe just a little bit closer to like 28 days or a month?
Let's see what we have to offer.
A lot of it is if I can get the lower court to kind of do what I've been trying to do, and kind of, obviously I'm not in favor with him for reasons stuck to myself, but if I can get him to get on board, it would alleviate all this issue, to be honest.
How about April 2nd at 11?
Write this down.
11:30,
Yeah,
I'm
let's-
sorry, 11:30.
I'm sorry, this is 4/2/26 at 11 a.m.
11:30,
Oh, 11:30, I'm sorry.
yeah.
11:30.
Which does
Okay,
allow-
let's yeah, let's pencil that in, and hopefully maybe I can work with this guy in the county court, because I already know there's probably another warrant out. But it's just been costing me a lot of money in lodging and travels, and that recent thing that happened. I mean, we're talking about $2,000 a trip at this point. I mean, it's I don't know who's got this kind of money, but anyways, yeah, I guess we'll
Right,
pencil that in,
and that's later in the day, so it should accommodate some travel. So we have,
well, and hopefully,
Go
yeah,
ahead.
hopefully, like I said, I can get a hold of Mr. Lynch, or Judge Lynch, I should say, and have him remedy the warrant situation. Hopefully, consolidate the cases, but I can't seem to get him to budge right now.
all right, well, I'll leave that between you and him, and we'll see you on the 2nd of April, 11:30 for an arraignment, and I will take your not guilty plea at that time and set it for trial.
All right,
And we,
you
yeah,
have a
in
good day.
person, as you know. Thank you.
All right, you have a good day, Finley. Honorable Finley. Have a good day, sir. We're good? Okay, I'm leaving.
Yep, you're welcome to leave. Thank you.